Okay, sorry about that. I had begun slide 30 and was interrupted with my computer restarting. So I'm going to continue on to slide 30. The duties of shareholders and the powers of the shareholder. The first and primary duty that they have is to elect and remove board of director members. It will be important for purposes of the exam to know who elects the board of directors and who appoints the officers. And those are two different people. The board of directors appoints the officers and the shareholders elect the directors. In addition, it'll be important for you to kind of know what the different powers of each of the three different parties are. The officers' powers are the day-to-day operations of the business. Do we want to run a sale today? That kind of thing. The powers of the board of directors are to establish overall policy of the corporation. Do we want to get involved in the sale of motorboats? Do we want to declare a dividend this year? What kind of bank financing will we approve for the officers? That kind of thing. The shareholders' powers are the largest powers, and those are the huge, gigantic type of decisions. Are we going out of business by selling all of our assets or dissolving the corporation? Do we want to, for example, merge with Kmart if we are Sears? That has to be approved by the shareholders. Do we want to amend the articles of incorporation or the bylaws? Again, that has to be approved by the shareholders. A meeting of the shareholders is required at least annually. So is a meeting of the board of directors, for that matter. Both require at least an annual meeting. In order to do business, a quorum must be present. For our purposes, normally a quorum is a majority of interest. Let's take the example of 9 members of a board of directors. A quorum of that would be 5, and that means that at least 5 board of directors must be present in order for a meeting to take place and for any valid action of that meeting to take place. And I know I'm kind of getting ahead of myself, but it really applies the same way for directors' meetings as well as shareholders' meetings. Now let's take that same example and let's ask the question of how many votes would it take to legally pass a corporate action with a 9-member board of directors. Your knee-jerk answer to that might be 5, and that's not correct. 5 is a quorum. So let's assume that you have 9 members on your board, but only 5 of them are present at a meeting. First question is, can the meeting take place? Answer, yes, because a quorum, being a majority, is present. Second question is, now that you have a quorum, how many must vote in favor of some certain proposal for it to be a valid legal action? And for our purposes, that's almost always a majority of those that are present. So 5 are present. 3 of them would be required to vote in favor of something for valid legal corporate action to take place. So see how that worked? We started with 9 members on the board of directors, but yet I just showed you how you can pass legal corporate action with only 3 votes in a particular given circumstance. Obviously, if all 9 of them were present, then you'd have to have 5 of them vote in favor of a certain legal action. And the same thing applies for shareholder meetings, except it's 50% of the shares, not 50% of the shareholders. For example, if you had 1,000 shares that were outstanding, you would need 501 shares to be at a shareholders meeting, which is a majority. Not 500, that's 50-50, that's not a majority, 501. Same thing on board of directors. Let's assume you had 8 members of the board of directors. 4 is not a quorum. 5 is. 5 is a majority, 4 is not. In order to give notice of meetings, normally an annual meeting can be for any particular purpose. However, special shareholder meetings can also be called, and generally it must be sent with sufficient notice, sufficient time, and in Alabama that's at least a 10-day notice for the most part. And the notice must state the purpose of the special meeting. Unlike an annual meeting where anything can be discussed, if it's a special meeting, it must be limited to whatever topics are described in the notice. Nothing else would be valid. Now be careful, I'm bad about asking questions on an exam like that. If I give you a special notice of meeting to discuss the declaring of a dividend, and at the meeting someone raises the question about whether or not the corporation should approve the borrowing of $1 million from a bank, you have to be aware that that is not a proper subject for that meeting. It would be at an annual meeting because anything goes at an annual meeting, but it would not be for a special meeting unless corporate financing and borrowing money was described in the notice itself. So be aware of that. In some cases, a supermajority of shares voting must take place for valid action to occur. And that's usually the very biggest kind of decisions. The PowerPoint slide here says sale of assets. It really should say sale of assets other than in the ordinary course of business. If you've got a company and you want to sell a piece of equipment, a car, a truck, fine. You can sell that without requiring a shareholder vote and certainly without requiring a supermajority. But let's say that you are Sears and you want to sell off your automotive division. That is a sale other than in the ordinary course of business. It would require a supermajority, which is usually more than 2/3 of the outstanding shares. Sorry about that delay. Slide 35 shows certain rights that shareholders have. The one that I want to specifically mention, or actually want to mention a couple, one of them is to inspect corporate records, and that includes usually there's a certain minimum. For example, in Alabama, you have to be at least a 10% shareholder in order to have, a 5% shareholder in order to have the right to demand to inspect corporate records. And if you think about this, this makes sense. Could I march into Bentonville, Arkansas, or wherever a Walmart's principal office, home office is these days, with my 1 share of stock I own in Walmart and say, shut down the company, I need to see all of your corporate books and records. Obviously, that wouldn't make sense, and so most state laws require a certain minimum. 5% is pretty common. That is the law in Alabama. And what I think is, I think that makes a lot of sense. If you're a 5% shareholder of Walmart, you have a ton of money and a ton of influence and are very, very important and probably need that right. The last power or the last right that you should see in slide 35 is to file suit on behalf of the corporation. That's known as a shareholder derivative lawsuit. If you are successful in recovering funds for the corporation, the money doesn't go to you, it goes to the corporation's treasury. Obviously, as a shareholder, and if you're successful in a great big lawsuit, then the value of your shares may increase, but technically the money does not go to you in a shareholder derivative lawsuit. Preemptive rights is a right of a shareholder to purchase new shares of stock when the corporation decides to issue new shares. And preemptive rights must be provided in the Articles of Incorporation. You don't necessarily have them unless they are provided there in the Articles of Incorporation. And let me give you an example of that. You've got Abel, Baker, and Charlie that each own 300 shares of stock in Acme Corporation. And Acme decides it's going to issue 300 more shares of stock. Well, if those 300 more shares of stock go to Delta and she purchases those shares, then Abel, Baker, and Charlie's shares will be not worth as much anymore in the corporation because their percentage ownership will decrease. And so preemptive rights is a way to prevent dilution and loss of control of shareholders by allowing Abel, Baker, and Charlie to continue purchasing shares in the same percentage as what they previously owned. Now, they may not have that right. They may not have the right to have a preemptive rights and purchase shares, but if they do, it will be contained in the Articles of Incorporation. When I mentioned shareholder derivative lawsuits a few minutes ago, I did not mention generally what the basis for these are. Generally, a shareholder derivative lawsuit is going to be on behalf of the corporation because the directors failed to correct some wrongdoing that took place. Basically, the directors would have the right to pursue a case on behalf of the corporation, but if they fail to take action, a lot of times it's because the shareholders think the directors were involved in the wrongdoing, and if they fail to take action, the shareholder can bring that shareholder derivative lawsuit themselves. And usually, as I mentioned before, shareholders do not have personal liability for acts of the corporation, and that applies to contracts or torts. Interestingly, there is a duty that was created under common law that the majority shareholders have to also look out not only for the corporation, but also to the minority shareholders. There have been lawsuits, they call these squeeze-out lawsuits, where minority shareholders allege that majority shareholders are taking actions that are not in the best interest of the minority, and they're being squeezed out of the corporation. So under common law, majority shareholders have not only the fiduciary duty to the corporation, but also to the minority shareholders as well. And the last 3 or 4 slides are very, very good chart showing the various types of ownership that we've discussed, sole proprietor, various type of entities that we've discussed, sole proprietorships, partnerships, and corporations. It's a nice checklist. It's a good way to test yourself to see if you remember how things are created, which ones have personal liability or unlimited liability, which ones do not, how long the various entities last, and if they are terminated and under what conditions are they terminated, how taxation occurs. Are they a flow-through or pass-through tax entity? Is there personal liability on the income tax? When does double taxation occur, if at all? And how does it occur? Who owns each one? It'll be important for you to know that on the test. Shareholders own corporations. Members own limited liability companies. Partners own general partnerships and limited partnerships. How are they created? We talked about verbal agreements being good enough for general partnerships and sole proprietorships. We talked about the articles of organization being appropriate for establishing a limited liability company and being filed with the Secretary of State and the Judge of Probate. We talked about articles of incorporation being filed for a corporation with the Judge of Probate and the Secretary of State. Under new Alabama law, you can actually have something called a certificate of formation that will form a corporation or a limited liability company, either one. It's a good checklist here for liability purposes as well. For limited partnerships, limited liability companies, and limited liability partnerships. Use that as a good checklist. It's a good way to study. Make sure you understand everything. And that's all that I have. Thank you very much.